I'm not sure how wise it was of me to put up a graphic like this on the screen after all the controversy there's been about those kinds of statements, but I'm on a completely different topic than the topic where you have usually seen reference to statements like that. I'm talking about what happens to your relationship with your doctor, your dentist, your therapist, your chiropractor when you file a Chapter 7 or a Chapter 13 bankruptcy. Now, the first thing I want to tell you is that the law does not make any guarantees that your treatment provider is going to keep treating. The law does not require that. I'm talking about what my experience has been as a practical matter, what my clients are reporting back to me, and what I'm finding when I correspond with some of these providers about whether they are willing to continue treating you, continue to do business with you. And the answer is that they almost always are. In fact, I've never had a case where any client of mine experienced a refusal to treat by a chiropractor, a doctor, a dentist, a therapist, any kind of a healthcare provider after the bill has been listed in a bankruptcy. What I like to do if I'm communicating directly with the provider is to explain that when you file a Chapter 7 or a Chapter 13 bankruptcy, you are not allowed to pick and choose which of the creditors you're going to list. You have to list them all. So I like to say, Ms. So-and-so didn't list you because she wanted to. She listed you because she had to. And it is her hope that she can still go back and continue treating with you because she really likes you. The only providers that I'm aware of, that I've experienced or even heard of, who would refuse to treat was a veterinarian in Wayzata. And the other one was something that another lawyer I know heard about from one of his clients, and that was a dentist in Elk River. Everybody else, as the vast majority rule has been, the healthcare provider will almost always say, "We're sorry to hear of your troubles." What they do is they will roll your account back to the day the bankruptcy was filed. As of the day, whatever you owed on the day the bankruptcy was filed is discharged in the bankruptcy, assuming it's a successful bankruptcy. But then anything you accumulate after that date's a new bill, and they get to charge you for that. Another thing you should know is that the insurance company, their obligation to pay, if you have health insurance or any kind of medical insurance you have, their obligation to pay the bill is not affected by your bankruptcy. The insurance company isn't filing a bankruptcy, only you are. So all that's affected is the part of the bill that you have to pay. And like I said, ordinarily they say, "Gosh, we're sorry you're having these kinds of troubles. We hope that all works out.